Alright, welcome back. This is Patents 1 Part 2 and we're in the textbook at pages 643 to 650. And I left the definition that we had here because it's going to be helpful going forward. So as we said, right, what is necessary for you to get a patent with the government under the registry? Well, you need patentable subject matter. So one of the things that the government says is protected, right? One of the types of inventions that the government says are protected, and it has to be novel, useful, non-obvious. And we said why the government give you a patent because there's this bargain, right? You get a monopoly in exchange for disclosing your invention, and that's a good thing because people get access to it in 20 years, right, as competitors, and in the meantime, as consumers, ostensibly, right? So, what is patentable subject matter, you ask? Well, it's defined in the Patents Act, right, in a way that is very broad, right? And the issue you're told, right, is whether that involves some sort of a moral standard, right? So, Section 2 of the Patents Act has the definition, right? So, what is statutory subject matter, right? It is an invention. So, you cannot get a patent unless you have an invention. The statutory subject matter. That's in Section 2. Section 2 says, right, what's an invention? An invention is any new and useful art, we'll see what these mean, process, machine, manufacture, composition of matter. That's the broadest one, right? Composition of matter, atoms, right? It's pretty broad. Or any new or useful improvement in any of these things. Any art, process, machine, manufacture, or composition of matter. Very broad, as I said. Also commercial, right? These are things typically that are useful to people that people want to buy and therefore that you're interested in selling. So, does that involve some sort of a moral standard? Well, from reading it, the answer is no. So there's no place for the court to say, well, this is patentable subject matter, but it's wrong to give you a patent, so we won't give it to you. There's no discretion there, not in the language of the Act. And so neither the commissioner, the examiner, the person in the government reading your application deciding to give you a patent, neither that person nor the court can use their discretion to do that. Of course, they'll find a way to do it if they want to do it, and that's essentially what the court does here. So you're told, right, that there's no explicit standard of a moral norm, right? But the court is going to say, if you don't meet that standard, that it's not patentable subject matter. So the court's going to say it don't meet the definition under Section 2, right? So the court is either going to say, right, it's not new. Any of the main words in the definition I just read you. It's not new. It's not useful. It's not an invention. You didn't invent it, right? Or it's not new, or it's not useful. And that kind of incorporates an implicit moral standard into the definition. You're given the example of someone who had this machine to kill people. The court said this is not useful. Actually, it might be very useful, right? It might help you achieve your aim, which is to kill people. The court says it's not a legitimate aim, and therefore it is not useful. Then you have, right, this notion that's mentioned of public order, right? Ordre public, as we said, we used this before, right? These are basically things where, you know, the law shouldn't intervene because it's wrong, right? You might have a legitimate contract for the sale of drugs, and your contract might meet the various conditions. Similarly, you can have a contract for a surrogate mother. Then the courts say, right, by virtue of the law, typically either the common law or the law is written down, the court says this is against public order. So this might be a legitimate contract in terms of meeting the conditions, but it's not one that we will enforce. Why is that? Because it's against public order. It's against the public interest. It's against what we believe in as a society, essentially. And so the book says that there's a notion of public order that's incorporated by this standard. And you have a case on this, which is the Harvard College case, which discusses a bunch of very interesting issues, right? And in that case, you have two groups of judges. You have Justice Binney, who is writing for the minority, and you have Justice Bastarache, who's writing for the majority. And as we'll see, Justice Binney is not very happy with what the majority does. The beginning of what you're given, page 644, is the minority, right? And what do they say? Well, they go back to this United States distinction. So they say, right, when they came up with the Patents Act in Canada, there wasn't much to go off of, right? The government just wrote down the act. It wasn't quite clear what they wanted it to mean because it was just a bunch of words. And so they looked to the United States because the definitions were similar. And the United States had had it for a long time. One of the key distinctions, though, in the United States is that what they say is they want to favor innovation. It's not quite what we say here. What we say here is we want to have useful inventions for people. It's a different standard. It's not inventing things for the sake of inventing things, right? It's inventing things to help people, right? To be useful to people who buy it. Regardless, the court uses some United States Supreme Court jurisprudence, right? And, right, you have this bacteria that someone tries to patent. They come up with this bacteria. The key thing is that the bacteria is alive. And what it does is it cleans up oil spills, essentially. And the court says, right, basically, there's no reason for that not to be patentable because you've invented it. It does something new and it does what you say it does. The minority, right, this is going to get a bit confusing. The minority in the Harvard College case says that. Well, look what the case says afterwards. Then you have the facts of the case. It's background. The facts of the case. The specific case to what this is applied is Harvard College, right? Ostensibly a professor at that university comes up with a mouse, essentially, right? They come up with a genetically modified mouse, which is great because it can catch cancer without you giving it much exposure to what causes cancer. And that's good because that's what happens in humans, right? So instead of having a normal mouse and then giving it cancer, which is, harder and doesn't replicate what happens in the real world, you create a mouse by changing its DNA that is predisposed to getting cancer, and as a result, kind of replicates how people get cancer in the real world. And so Harvard College says, we've invented this, it's great, we want a patent on it. Why is that? Ostensibly because everyone inventing drugs tests them on mice, and they'll prefer that mouse, and if you're the only one that can sell it for 20 years, you're going to make a lot of money and fund your university, right? And what happens, right? How do we incorporate this moral standard that's been hidden in the definition of an invention under Section 2 of the Patents Act, which, as I said, does not have such a moral standard explicitly? And the court in the United States, right, interprets it very broadly. They say the act was meant, there's this phrase that's taken from a congressman, to patent everything made by a man under the sun. The court says it should be interpreted broadly because that's their purpose, so it should, prima facie cover the mouse because it's meant to be broad, right? What does a court do when it wants to interpret what the law says? It's only a sentence, right? It looks at what the people who wrote it down meant, and typically what they said in the debates or what they said in the journals that led to it. And what will the Supreme Court of Canada say? Essentially, the Supreme Court of Canada will say, no, that's not a really good idea, we won't do it. And you'll have Justice Binney, for the minority, will say, you're dumb, you got it wrong, this is silly. What's important, though, before we move on, right, is that the distinction here is that it's alive, right? Patenting human nature is sometimes permitted, right? As I said in a previous week, a drug is not magical. A drug is a molecule that generally we know about, and when you give it to someone, it has an impact that you want it to have. And so it's just a molecule, right, which we know about until you prove, essentially spending, $5 or $10 million in the process with double-blind trials and all that can cure people with a specific disease. Then it's a drug. Molecule with an effect is a drug. You're patenting a molecule, not the molecule itself. Obviously, people, can still make it. You're patenting for that use. As I said earlier, right, use bounds your protection. You're protected by the monopoly for that use. So, that drug, anyone can make it, but they can't sell it as a drug to treat whatever you're treating for the 20-year period. And the court says, right, organic stuff like molecules are covered usually. That's what drugs are about, and drugs are the most profitable ways to get a patent. So why is it that mice wouldn't be protected, right? And the court gets away with this very, very interestingly. So the court doesn't say this is wrong because, as we said, there's no standard, right? What the court says is it's not an invention. You didn't invent it, right? The court looks at, what is it? A composition of subject matter, as I said. That's in the definition of invention, which is subject matter. So one of the criteria, subject matter, patentable subject matter under the Act. What is that? An invention. Why? Section 2. And as we said, Section 2 is very broad. One of the things that counts as an invention is a composition of matter. And that's anything, right? That's carbon, that's molecules, that's everything that exists, right? Does that include it, right? And the court analyzes these three words, the composition of matter, and says, no, it's not covered. And why is that, right? Because you have to have made it, right? And in that case, you did not make it. So in other words, right, what's wrong is that you do have a composition of matter, but it's not an invention. It's not new. You haven't invented the composition of matter, which is also in Section 2 in the definition of an invention, right? You just have to understand the broad strokes of it, right? Well, you didn't make it. You made up the DNA change such that you'd get a mouse, but that's not enough. Because then, you change the DNA, but, right, the mice procreated and they did all the work. You did not invent it, and therefore you don't have a patent over the resulting mouse. That's essentially what the government says, right, what the court says. And so in Canada, that's the final answer, the mouse is not protected, is not patentable subject matter. And the court makes some pretty interesting analogies as to, whether a human being, if you change your DNA or you change a part of them, you give them, a medication, whether that changes their identity, and the court says no. And that's where they get into trouble with Justice Binney, is when they start talking about identity. When they start saying this is different because it has an identity, it's alive. It's what makes it different from a drug. It's what makes it not protected for whatever reason we come up with, but that essentially incorporates the moral standard directly or indirectly, right? And essentially, it's because it's wrong, right? And the court says, right, if we change the composition of a human being, it doesn't change who they are, right? Because, we're more than that, and therefore, that's not the nature of what we're protecting. What's interesting, though, to think about is, why does the court come up with that? And the answer is, we don't really know, right? Because what is it that is so bad about owning things, right? About owning human beings? Why is it that we can own cats, which are, ostensibly sentient sentient beings, right? As the court describes them, things that are conscious. A cat is conscious. You can own a cat. You can have a human being own another, form of life, and that's allowed. So why is it that it's so bad to have a patent? And I don't know. If we go off that analogy, it probably has something to do with a monopoly. We don't want you to be the only one who can own a certain type of life. Not because, ostensibly, right, I don't know, not because it's wrong to own life, but because it's wrong to have a monopoly over life. That's my best hypothesis there, right? And then Justice Binney, as I said earlier, gets mad. Justice Binney, for the minority, says this is junk, it doesn't make sense. And why is that? Essentially because of that. He's saying, right, you're incorporating this moral standard, which is not written down and which is bizarre, because it's not what the law says, and it's not what the law should say. The law shouldn't be concerned with assessing what human life is and assessing whether you can invent a mouse, right? And drawing a standard there that you're calling something else, right? He says, this is not the law. This is metaphysics, right? A, it's bullcrap because it's not there. And B, it's bullcrap because that's not our job. If there's people in the world who can decide whether something's alive and that should be patented or not, or whether being conscious changes something, or even what it means to be conscious, it shouldn't be me. It shouldn't be me, Justice Ian Binney of the Supreme Court of Canada, who is the least, legitimate person, because I'm elected, and the least competent person to make that decision. And he cites, as you're told, at page 649, right, basically a case to that, a book to that effect on metaphysics. So what else can you have that's protected as an invention under Section 2? Well, you can have a manufacturing process, and you're given a description at page 650, which is pretty self-explanatory. Essentially, right, what is it? It's basically a way to make something, right? Something that helps you make something, take something from a material to something else. And why is that helpful in that case? Because Harvard College was trying to get here basically protection over two things. They were trying to get protection over the resulting mouse, as I said, because they've invented it. That's protect, it's invention in itself. They also try to get protection on the process. So the genetic modification, they said, we invented the way to make the mouse, and that's also an invention. And so they claim protection under both, right? In Canada, neither really is protected. In the United States, it's a different story.